facing murder charges will continue to be held without bond as his case moves forward. His attorney is now trying to argue he killed his friend in self-defense. So criminal defense attorney Joseph Tully joining us now to break this case down for us. Joseph, good to see you as always. This one made national, global headlines. A lot of questions surrounding how did this happen? I mean, he does not have arms. He does not have legs. There are videos of him that he has posted himself showing him shooting a shotgun, a 9mm, so we know that it is technically possible. But kind of walk us through where the case stands right now. He was extradited from Virginia back to Maryland.
Yes, so he was in Virginia. The case allegedly took place, the incident in Maryland, and that's where the charges were filed in state court there. Today's hearing was only an extradition. He didn't fight it. He waived it, meaning he can now be transported to Maryland to face charges in state court. The initial phase of the case will be going to preliminary hearing, and at that time, the judge will hear initial details about the case to see whether or not the case should go to trial. And that's usually a yes, and I would imagine because this is a serious case, we'll eventually see it in trial in about a year to a year and a half.
Now, what are the parameters if his attorneys are already claiming self-defense? So as we understand from Charles County Sheriff's Office, Dayton Weber was the driver of a vehicle. His front seat passenger is the one who was shot and killed. His attorneys appear to be claiming self-defense. What are the parameters in Maryland to make that defense?
Sure. So self-defense is really when you're facing immediate threat to your life or serious health injury. So if somebody's going to beat you very badly, or if you're in imminent threat of serious bodily injury or death, that's when you can use self-defense. Now, this case is interesting because there are two witnesses reportedly in the back seat who saw everything. And in my view, this case, the self-defense claim, will ride on what the witnesses' statements are. If it justifies the use of force because he was in imminent danger of serious bodily injury or death, then I think this could he could be found not guilty or charges could be dismissed. Those are both within the realm of possibilities. But basically, to me, this case will rise or fall on the neutral witness statements who can give details of what occurred in that car that day.
All right. So according to court documents, there were two people in the back seat, and Dayton asked them to help dispose of the body. They said no. They jumped out. And they're the ones who flagged down police and kind of told them exactly what happened. The body was dumped in Maryland. He was later arrested in Virginia. So a lot of moving parts and pieces to this case, and obviously a lot of interest.
Certainly, this is a very intriguing case for a lot of different reasons. Self-defense law is very nuanced, but according to his attorneys, he has a clear-cut case. That's what they're saying to me. I wouldn't say that unless I had very solid evidence to say that. You don't want to egg on your face later because then you lose credibility. So for them to be saying that, it may be that the witness statements support that, but we'll have to wait until more evidence comes out.
Still lots more to come on that one. Criminal defense attorney Joseph Tully, thank you so much for the breakdown, as always.
Thank you for having me. Take care.
Okay, we're just getting started here on the DMV Zone on a Wednesday. Stay with us. We're back after this break.